Welcome to A Taste of Justice. I'm Professor Angela May Kupenda, and this is our First Amendment speech portion of the series. The First Amendment is a very short amendment. However, there are many court cases interpreting what the amendment means. All explanations of those cases, however, are my own and are not to be ascribed to my school or my students. For now, I tell you, though, that I am a professor of law at Mississippi College School of Law. Let's get right to it. We started with our general rule. The general rule is that pure speech is protected from content regulation unless, and one big unless is, unless the speech is in an unprotected category. Now, in several videos, we talked about the unprotected category of speech that advocates illegal action. We will return to that topic for a little bit of a review later on, but for now, we're going to move into a second category of unprotected speech, and that category is defamation. Defamation. Now, with speech that advocates illegal action, we looked at some of the reasons why government may have wanted to regulate that speech. Government may have been concerned that the speech was hindering a war effort, for example, or the speech may lead to an unlawful overthrow of the government. But so defamation, why would a government, specifically, this would be generally a state, why would a state want to have laws that punished individuals, in a sense, for saying something that may harm another person's reputation? Now, last time we were talking about, there was a saying that that sticks and stones may break my bones, but words would never hurt me. And we talked about a little as to whether that is exactly true. So a state may want to have a defamation law, whereas if an individual's speech caused harm to another person's reputation because it was untruthful or the spreading of lies, that the individual whose reputation is harmed or damaged would be able to recover for that damage from someone spreading untruths. So for many people, that sounds okay. Many are concerned about their reputation, and they want to protect that reputation from harm by others, especially when the harm comes from spreading things that are not true. So this brings us to how, with speech that advocates illegal action, we saw that the court came up with a test called the Brandenburg Test, the modern day test. So for defamation, what is the case that lays out the test for us to determine whether a given message is defamatory and whether it is unprotected as defamation or whether it is allowed because of the First Amendment? You see, defamation, laws protecting defamation may clash with the First Amendment, especially if you believe in a more wide open First Amendment. Depending on what individuals say, reputations can be harmed. So how has the court balanced the two? the state's concern that individuals' reputations be protected from lies and mistruths versus an individual's right to speak or say whatever they want about whomever they want and however they want. How does the court balance the two? So I'm going to tell you a little story about the premier case dealing with defamation. And the premier case dealing with defamation, as you will see in the text box below, is New York Times versus Sullivan. So let's go back. New York Times versus Sullivan was decided in 1964. And that case is all about an ad, a paid ad that some ministers took out in the New York Times, and an Alabama police commissioner who said that the ad damaged his reputation and was defamation. So before we can look at the ad itself, and in the box below, I've given you the title and what you should Google if you want to take a look at the ad itself. And it is available in the government archives so you can see it. So think about the Deep South in the 1960s. You know, I was a girl then, and I was living in the Deep South in Mississippi. So during that time, a civil rights movement was growing. Black people, including myself, including yours truly, in the 1960s in Mississippi and in other places all over the country, but maybe especially in the Deep South or in the former slaveholding states, Black people were denied many, many freedoms. You know, as a little girl, I was not allowed when I was a girl to go into restaurants or to have a seat, to order a hamburger, to use a public bathroom. If white people approached us, my parents included, on the sidewalks, we were expected to step off the sidewalk even into the mud. Schools were segregated still, and the Black schools were underfunded. Brown versus Board had been decided in 1954, but many states, including Mississippi, were still resisting the holding that separate and unequal in public school K through 12 was unconstitutional. So these were the times, you know, we were in the back of the bus, and if more white people got on, you had to stand, even a little girl afraid of falling. And Black people were not, I'm going to say, were not allowed to vote, even though the 15th Amendment had given Black men to vote. And then in 1920, women had received the constitutional right to vote. Black people were not allowed to vote in many places. If you went and you tried to register to vote, then you may be terrorized by the government, and you may also lose your employment. So these were the times, and the civil rights movement was growing to try to bring about more racial equality. So the civil rights movement was a movement that was supported with peaceful marches and protests by men and women and children, by Blacks and whites and other racial groups seeking for racial equality for people who were not white. Now, often these marches were met by the government You've probably seen the documentary, documentary. Look, the documentary involving the march in Selma, Alabama, across that bridge. So fire hoses, dogs, etc., were used by police to stop people from a lawful protest, a peaceful protest in their Sunday best. The marchers often marched dressed in their Sunday best. So all of this is important for the background of New York Times versus Sullivan. So the civil rights participants would be arrested. So they needed to raise funds to pay for the bail, to pay for transportation, to pay for many expenses of the movement for racial justice. So a group of them took out an ad in the New York Times magazine. And the New York Times, they saw the list of people who supported the ad, and they figured that this is truthful. So they received payment for the ad, and they ran the ad in the New York Times newspaper. It had a heading that said, "Heed their rising voices," and it solicited donations from people all over the place who would help, who would financially help and support this movement for racial justice and civil liberties. Now, the ad had some errors in it, some mistakes. The errors were minor, but there were mistakes nevertheless. For example, Dr. King had been arrested, but the ad had the wrong number of times that he had been arrested. For example, as another example, when some of the young people had marched, they had sang one song, but the ad stated a different song that they sang. The ad said that the police had rang out on a campus. The police had been heavily deployed to the campus. So there, the story of the ad was correct and ongoing, but there were some minor errors. So now you're probably asking, so where was the defamation? You know, defamation is the publication of a false statement that injures the reputation of another. And did they call out any specific police officers' names? They did not. But one of the police commissioners in Alabama, Sullivan, Officer Sullivan, he said, everyone knows they were talking about me. And they were talking about me negatively, and people know it was me, even though they did not call my name. It's also interesting to note that the New York Times was not widely distributed or purchased in Alabama in terms of any injuries to the officer's reputation. So you're like, well, what's this about? The ad seems to be essentially true. Again, how is this defamation? So as I said, Alabama had a law, and under the Alabama law, any expression of opinion, in order to be protected by the First Amendment, it had to be completely 100% accurate. It had to be 100% accurate. And here, there were some minor errors. So the officer, the police commissioner Sullivan, brings suit against the New York Times and 4 ministers. Now, some who have written about this case, they say that what was really at stake was not so much that the ministers would have to pay, but to stop the media. You see, during those times, so many things that were happening, especially in the South, people who did not live in the South, and even some who did not really believe that it could be that bad. So here, there may have been an attempt to stop the media from reporting on these things so that the South would be able to continue the way it was in terms of racially and politically subjugating those individuals who were not white. Now, when you go and pull up that ad, you're going to be amazed at the just diversity of people racially and their careers who gave support to this ad and support to racial justice. Their names were printed on the ad itself. Let me call out a few of these names and see if you recognize any of these individuals. Signing on to the ad was Harry Belafonte, you know him, Marlon Brando, Diane Carroll, Nat King Cole, and Sammy Davis Jr. What about the great poet Langston Hughes? The wonderful gospel singer Mahalia Jackson signed on, Eartha Kitt, John Lewis, who later became a congressman and recently passed away. What about Sidney Poitier? And then another person who signed on to the civil rights ad was a former First Lady, Mrs. Eleanor Roosevelt, and also a number of civil rights leaders who were active in the movement. So this police commissioner, Sullivan, filed suit under the Alabama law. He says, they've hurt my reputation. What they said in the ad was not 100% accurate. And so therefore, he was entitled, he argued, to recovery under the Alabama law. Now, I already mentioned that Black people had great difficulty in registering to vote during those times in the South. And in many places, being registered to vote is a requirement for serving on the jury. So it won't be surprising to you to know that the judge who presided over the case was a white male, and also the jury was made up of all white men. After all of the evidence was introduced in the case, the jury deliberated for a very short while, and they brought back a verdict for Police Commissioner Sullivan. And you may say, how much? Well, remember, this was 1964. They brought back a verdict for him for $500,000, $500,000, which is the amount that he had requested. So now we have this case on appeal to the United States Supreme Court as to whether this verdict would be upheld, whether or not Sullivan was defamed, and whether this Alabama law will stand up. So we have the Alabama law protecting reputations unless the statements are 100% true, then we have the First Amendment. So we have a clash between the Alabama state law and the First Amendment. So how do you think the case turned out? What do you think the court held? Well, before I tell you, well, I'll go ahead and tell you, Sullivan lost the verdict. He did not collect that $500,000. And you're like, well, how did we get there? There was a state law. It appears that the law was violated. So the First Amendment obviously triumphed in that clash. The First Amendment obviously triumphed over the Alabama state law. How did the court get to that point? Well, the court said several things. One thing the court said was, first, let us just point out, the goal of the First Amendment is not to protect lies and misrepresentations. The court said the First Amendment is not there to protect misrepresentations, misstatements, and lies. But then the court came with second, but, or however. You know the court said that. However, let me just read the statement to you. Erroneous statement is inevitable in free debate, and it must be protected if freedom of expression is to have the breathing space it needs to survive. What a statement. I've repeated them in the bottom in the text if you want to put that on someone who accused you of making a slight misstatement. The court says that in free debate, it is almost unavoidable that there will be a misstatement. So the First Amendment is not to protect a lie, but if we want free debate, there may be a misstatement if we want the First Amendment to have some breathing room. The court wasn't through. It said, third, where the discussion is about public officials and their official conduct, we want, what the court said, robust, uninhibited debate, which means you may come up to the line. If we have the truth here and lies here, somewhere where it gets shady, the court says that we may come up to that line and cross it. But if the statement is about a public official, in that official's official conduct, then the First Amendment ought to protect you when you just kind of step over the line of truth a little. And fourth, the court said, and fourth, public officials have self-help. A public official in their official conduct can call a press conference. They can release a public statement. They can do a public interview, and people will hear out their side, according to the court. The court said private people do not have that same opportunity. So if they are defamed, a private person, you call, look, if I call a press conference, are you gonna come? Are you gonna come to hear what I have to say? The court said, likely not. But a public official, a governor, a mayor, a president, call a press conference, then people will, congressional representative, a senator, they have an opportunity to correct misstatements. So in the New York Times and later in several other cases where I give you their names and dates so you can Google them and learn and read more about them, the court says where we have a public official and their official conduct or a public figure, then that rule is different from if we have a private individual. Now, Let me pause a second so we would know just what we're talking about. We're talking about public officials and their official conduct. But what does that mean? Does it include their private lives? Well, there have been some cases that said the higher up a public official goes, even the personal may become official conduct, right? If the public official is speaking about being true, being honest, being a great citizen, and we find out in their private lives that they are not, the court said that may all be a part of public official and their official conduct. So you have both of those things you have to look for to see. Lower ranking public officials. Look, even a public school teacher is a public official. A local police officer is a public official. The janitor, perhaps, at a school works for the public government, but the court says that we look for the public official in their official conduct, and the higher up they are, or if they're running for office or what have you, then more and more things become a part of their official conduct, okay? And those individuals are different from us private individuals in terms of the amount of protection that we may need to protect our reputations. The other group, the court said, is just like the public officials, and that's public figures. So what are public figures? The court said a public figure is a private person who has thrust themselves to the forefront of a particular controversy. So a person can be a public figure for some purposes, a public figure for all purposes. Let's say a person has some kind of reality show, and then I would think they're probably a public figure. And if the reality show is showing what goes on in their home, are they a public figure for all purposes? The more you're out there because of your governmental position or because you place yourselves out there, then the court says the more you can take care of yourself when there are misstatements made that may damage your reputation. And I'm paraphrasing here. Now, what did the court say? What is the test? So for public officials in their official conduct, or for public figures who have thrust themselves into a controversy, the court says the test is actual malice. Now, what does that mean? If there is a misstatement made about public figures in the matters where they've placed themselves at the forefront, or public officials in their official conduct, even if there is a lie told about them, the court said they cannot recover in defamation unless they can show that the false statement was made with actual malice. And actual malice means with knowledge that it is false, or with reckless disregard of the falsity. And I've printed that at the bottom. For the rest of us private figures, the court said if a state wants to, it can protect our reputation more. But it has to have some degree, requires some degree of fault. So a private person can recover for defamation if the state provides a law, and the state can provide a law with a requirement as low as negligence. If someone negligently tells a lie about you, that damages your reputation. So here we have this. Now, punitive damages. Punitive damages, more and more disfavored. But the court said that for that private individual, the state can allow for punitive damages and actual damages. But for punitive damages, even for us private people, you have to require at least a showing of actual malice. So this is defamation. The case is New York Times versus Sullivan. But what does this mean for our times? What does it mean? Look, let's say you have a Twitter account. You're just a private person with a Twitter account, but your account has a huge following, and you're commenting on all kinds of things, matters of public concern. You have a huge following, and someone tells a lie on you that damages your reputation. Are you a private figure where the state can protect your reputation more? Or are you a public figure, right? Let's say, for example, that you whisper a little gossip, a defamatory message about a person from one to another. Can you be sued for that? But what if you whisper a message by using a, private Facebook account or in a text or an email, and it gets out, it's published by someone else? Can you then be sued for defamation? Who were you talking about? Was it a public official as to their official conduct, a public figure who has thrust themselves out there for all purposes or for a limited, a specific purpose that you're talking about? Or are you talking about a private person? That may indicate whether or not a suit against you for defamation will be, whether you will prevail or whether you would have a confrontation with the First Amendment. Another one, we used to say that for defamation, slander was like you say something orally, but libel was something written or typed, and libel was worse because there was a record. But what then are the messages on Facebook or on a Twitter or Instagram? Is that written or is that oral? So do these old distinctions even matter? What if you post a video that you've kind of sort of tampered with? Is that protected speech? So these questions, I know you're waiting on me to give answers to all of these questions. I'm not. I want you to think about it more. And in the next clip, we're going to complicate this even more. What if there's a statement that is not defamatory with the definition of defamatory, but is defamatory-like in the sense that it speaks about some private matters that a person did not want to disclose? Oh, wow. Remember, learning can lead to enlightenment to freedom, and freedom to justice. Our Constitution says that the preamble that we want to establish justice. So here in these clips about the First Amendment, I'm seeking to give you at least a taste of that justice. Subscribe and sign up for notifications. You don't want to miss a thing. See you next time.